Step 7. Trial Preparation. Let's talk about trial prep. Now, all of this is kind of trial prep, but it's also negotiation prep and case prep and helping you to figure out what it is that you want. When you are engaged in trial prep, here's what you're looking at. You need to identify all of the remaining issues that have not been settled: property divisions, spousal maintenance, parenting time, child support. Once you've identified the issues, then you need to look at the law to figure out the elements of each issue, for instance child support. Child support is calculated pursuant to a calculator. The elements of child support are mom's income, dad's income, childcare expenses, healthcare expenses, any extraordinary expenses. You need to drill down into the elements and make sure that you have the information that you need to prove each of those elements. How do you prove mom's income, dad's income, healthcare expenses? This is all information you're going to need in order to prepare for trial and prove your case. You'll need to look at the statutes, which you can find under Title 25 of the Arizona Revised Statutes. That's all of the family law statutes. If you look at each one, you know, the one on parenting time will give you all the factors that the judge will consider when determining what the appropriate parenting time arrangement is. At this point you are gathering legal information and analyzing that legal information and applying your facts to that legal information. Get help, consult the statutes, lay legal advocates, people who have been doing this before, doc preparers, attorneys. Do what you need to do to make sure this is you're very well prepared and you can articulate the facts and have the evidence that the judge actually cares about. Pretrial statement. There was a question about a pretrial statement. The pretrial statement is the most important document in your entire case. I cannot emphasize enough how important this document is. This document identifies all of your issues, gives the procedural history and background of the case, cites the law, applies your facts to the law and incorporates exhibits. Last week I had a hearing with a client. The other side was represented as well. We had submitted to the judge a joint pretrial statement laying out here's what's happened in the case, here are the outstanding issues, here is the law, here is how we applied, each of us each attorney applied our facts to the law and we gave it to the judge in advance. When we walked in for trial that day, the judge had written up for us his presumptive findings. He had already drafted his ruling. He called us back in chambers. He said, look, I'm open to changing my mind once I hear a testimony, but here's what I'm thinking I'm gonna do. It was incredible. This tells you how important this document is. If you pay an attorney for one piece of your case, I recommend you pay them to do a pre-hearing statement for you, take your exhibits, apply your exhibits. The reason is you're going to use this as an outline for everything. We can talk more about that if you'd like. Alright, what are you going to use for witnesses and exhibits? How do you determine what you're going to use or who you're going to use? You look at your pretrial statement. Your pretrial statement shows you what fact you must prove. If you must prove mom's income, you know that you need an exhibit that shows dad's income. If you have to prove that mom never showed up to pick up little Johnny on time, then you're going to need exhibits that show that mom never picked up little Johnny on time or witnesses from the childcare center that can say that mom never picked up little Johnny on time. If there are facts really important to you that cannot be applied to an element, you don't get to use them. So if there is something that is very important to you, for instance your ex cheated on you and you're pissed and you want the judge to know, I don't blame you, you know, it makes sense that you are upset and you want the judge to know, but we have a no-fault divorce state, so it's really not relevant, unless we can show waste, community waste of assets. If you put in legal argument and analysis related to waste, then you get to bring up the fact that your spouse cheated on you and spent all this money. You must figure out a way to get the facts that are important to you to apply to an element of a legal issue.